Hi, good afternoon if you're on the East Coast, and good morning if you're out west. My name is Aaron Lacey. I'm with Thompson Coburn, which is a law firm, and you are tuning into Gainful Employment, Disclosures, Student Warnings, and the Future of the Rule. And those of you who are tuned in probably already know something about what gainful employment is, and are probably, if you're like me, very interested in where things are going. So we're going to talk a little bit about that today. Before we get started, I've already put up, my information on the screen, but let me get through some housekeeping. This program is CLE, or Continuing Legal Education Certified. Certificates will be sent in the days following the webinar. Please remember that for CLE credit, so if you're an attorney out there and you're trying to get continuing legal education credit, you have to log in with the same email address you used to register for the webinar. This login is proof of attendance and supports our awarding of CLE to you. If you need to leave the webinar, you should log out and then log back in when you return. If you are seeking CLE credit for the webinar, you will need to verify your attendance. During the webinar, we will post 3 top secret code words. You should write them down because you will need to provide them in the verification form included with your login instructions. If you have CLE questions, that is questions relating to continuing legal education, you can send those to cle-tc@thompsoncoburn.com. And if that's hard to remember, just email us back, respond to one of the emails you got from us. The webinar is timed to last, this webinar specifically, about 90 minutes. So it's a little longer than normal. We have a fair amount to talk about, and we wanted to be sure to build in time for questions. We'll take questions at the end, but you can ask a question at any time. In order to do so, just open the chat box by clicking on the chat bubble in the top right-hand section of your screen. The webinar is being recorded and will be available free and demand within usually about 10 days on our TCLE website. If for some reason you can't locate the recorded webinar, don't hesitate to reach out to us. Also, please remember that if you are listening to this recording right now at some time after its original air date, meaning today, it is possible that law and guidance have changed. I mentioned at the outset, my name is Aaron Lacey, and I'm a partner here in the higher education practice at Thompson Coburn, which is a law firm based in St. Louis, Missouri. We have offices elsewhere, including in Washington, D.C. The higher education practice, we do a lot of things, but we, at least in my corner, provide regulatory counsel on federal, state, and accredited agency laws and standards. So we advise folks on all these different kinds of regulatory issues that you have if you're operating a post-secondary institution, whether that be for-profit or nonprofit, private nonprofit or state institution. We assist folks with a wide range of post-secondary transactions, so that could be a sale of schools, but also mergers and acquisitions, even among nonprofits. Do contract drafting, negotiating, write lots and lots of policies, and help folks design compliance systems. And anyone in higher ed these days knows that compliance has become a bigger part of the puzzle. And then finally, we'll represent schools in student and employee litigation. We actually have a pretty active litigation group here that does a fair amount of that. And then we'll also represent folks in front of agencies, and that's some of the work that I personally do, government investigations, administrative proceedings, so that's program reviews, audits, things like that with the Department of Education. Before I was at the law firm, I did spend 4 years in-house with a career education company, had 20-plus locations in and around the Midwest and Southeast. So I've been on the other side of the phone, and I do deeply appreciate how challenging it is not only to wrap the head around some of these regulatory concepts, but then to, hang up, disengage from the call and figure out what do you do now that you know what the law is, how do you operationalize these requirements at school, while also trying to actually educate students and run an institution. Before that, I spent about 8 years in Washington, D.C. with another law firm, still doing higher education work. Okay, enough about me. So the presentation outline today, we're going to start with politics and prognostications. I want to talk a little bit about what's going on in Washington, D.C., particularly with the U.S. Department of Education, and then specifically about the Gainful Employment Rule and the future of gainful employment. And if you're like me, this is some of the more interesting stuff. I'll put up a timeline. If you've listened to my prior webinars, you know I like to do that just to give people a sense of how things are happening and when they're happening. Then we're going to get into a little more depth with regard to the standard GE disclosures that folks are going to have to start making come July 1, and also student warnings that some people already should be making and others may have to start making in July or August. And then finally, as always, we have a couple of 3 links to resources for you. So politics and prognostications. By the way, there is your first secret word off to the right, and it is bulldogs. Bulldogs. All right. So who's in Washington, D.C. right now, at least when it comes to, you know, leadership and higher education policy? Obviously, you have the President of the United States, President Trump, and then you have Rob Goad. I don't know, some of you may know already, Mr. Goad was an aide to an Indiana congressman and had background in education policy, particularly with regard to sort of school choice and elementary and secondary policy, and has been appointed and is serving as the White House's education liaison, which is a good thing insofar, among other things, as it demonstrates that the White House has an interest in having someone whose job specifically is to liaise on education policy. There is no requirement in the law that you appoint an education liaison, so that's positive. And Mr. Goad is in the White House actually advising Mr. Trump and others, President Trump, on matters relating to education policy. You have Senator Alexander, who's the chair of the HELP Committee. That is the Health, Education, Labor, and Pension Committee on the Senate side, which manages all things higher education, including the reauthorization of the HEA. And many of you know that Senator Alexander was previously a Secretary of Education and the President of the University of Tennessee. So this is an individual that knows a lot about higher education, more than just a passing interest. Rep. Virginia Fox is the chairwoman of the House Education Workforce Committee, also has been very interested in career education to include the for-profit sector for many years, and has often been an advocate for career and for-profit schools, among others. And I highlight those types of schools because those are the schools that are primarily subject to, or at least feeling the impact of, gainful employment, and I suspect constitute the bulk of our attendees today. And then you have Secretary DeVos, who is the new Secretary of Education. What we know generally about these folks, at least with regard to the White House and executive agency side, is that their primary interest and background is in elementary, secondary, and school choice, to the extent they really have a background in education. President Trump obviously his background is elsewhere. And then Senator Alexander and Congresswoman Fox, we know, have pretty deep experience in the higher education sector in particular. What about the leadership at the department? And I mean, you know, sort of beyond Secretary DeVos. Well, so some of you may know there were these landing squads that arrived even before the inauguration to assist with the transition. And these were folks who, and I don't just mean in post-secondary, I mean in all areas of education, had previously been in Washington, D.C., may have worked under prior administrations at the department, may have involvement with think tanks or other organizations that specialize in education or higher education policy. So you had a group of 30, 40 individuals who were tapped to come in and to start thinking about what they wanted to do at the department after the inauguration, when all the senior officials and political appointees left, and to try to keep things moving. And also these are folks who could make recommendations on potential permanent hires at the department. So this landing squad group sort of morphed into what's been called the beachhead team. All this sounds very military-esque. And these folks were typically hired for a temporary period. I've seen thrown around 120 days. I haven't actually seen the employment contracts, but that is what I understand. And again, these aren't necessarily permanent hires. There's no doubt that some of them will transition into permanent roles at the department, or that would be the expectation, but others may in fact continue. They may have taken temporary leave from their jobs elsewhere just to come in for this short period of time, again, to help with the transition, to help identify permanent employees, et cetera. So this group of again, 30, 40, 50 individuals, many of them are savvy. They have prior department experience. They know their way around education policy. That being said, our understanding is that a fairly small number really have a lot of or significant post-secondary experience. So when you're thinking about things like gainful employment and the bar defense rule and some of these issues that are fairly specific to higher ed, you've got a much smaller group among this beachhead team that really have familiarity with those types of issues, right? The other thing we know, and there's been press along these lines, is that there's been pretty slow progress in nominating political hires and non-conferable staff at the department. So while you still have this group, this beachhead team that's in place and has a lot of experienced folks involved, nonetheless, you've got a lot of positions both, and when I say political hires, I mean the folks sort of at the top of the food chain at the department that would be appointed and confirmed by the Senate, and then non-confirmable staff. So these are folks who are below that most senior level, but not your career bureaucrats, right, sort of in between. To give you a sense, so this is a screenshot. There's a website you can go to at the Department of Education that shows all their senior officials. And if you look on the left, you will see, and this is current, I checked this morning, it still looks like this, they're all vacant, right? So you've got only a couple of folks who are filling these senior positions, and those are folks typically who had a contract that provided that they would stay in their position for a set period of time, even after you might have had an election and a change in administration, right? Even more meaningful to the folks on this line is this shot. So this is the same page lower down, and these are all the folks who would direct or typically be involved in higher education or post-secondary education policy. From the undersecretary on down, you see that Jim Runcie, who's your COO at Federal Student Aid, is the only holdover in this space. The other thing I'll point out is that in almost every one of these offices, so, you know, in the Office of Career, Technical, and Adult Education, the Office of Post-Secondary Education, you've probably got, or at least historically have had, 8 to 12 people before you got to the level of the career bureaucrats. So when you look across all of these and you count up, you know, 30 or 40 vacant positions, what that tells you is you've got probably somewhere between 200 and 300 spots that are vacant overall, right? That's a pretty big gap, and those are a lot of people who typically would be there helping to move things along and create policy and create direction. A couple other important notes. So we are seeing turnover at the department, not only at the level of the appointees and their staff, which is what we were looking at on the prior slide, but also among some of the senior bureaucrats who are really just aging out. And Jeff Baker's a perfect example of this. As many of you know, Jeff has been at the department for a very long time in higher education, financial aid, I think something like 35 or 40 years, and announced last fall his retirement. And there are others, I think, that fall into that category of being baby boomers who've been in the business of higher education policy for 30 or 40 years and have just decided that this is a time to move on. And it really has nothing to do particularly with this administration or any other administration. In fact, most of these folks have been through more than one administration during their tenure. It's just they're aging out. We also think there are going to be some who joined as part of what I'll call the Yes We Can generation, sort of coming in with the Obama administration, who will stick around. My initial thought months ago was that most of these folks would clear out and would not necessarily be interested in sticking on with the new administration that might take a very different policy direction. But as one of my partners in D.C. who does a lot of higher ed lobbying pointed out to me, first of all, the job market for Democrats these days in D.C. is not great. So if you're a 25-year-old and you're working with the department and that's what you do for a living, you might not be quick to leave your job. The other thing is the last administration on their way out encouraged these folks to stay to protect the Obama legacy. Right, so they were specifically asked to think about staying on for that purpose, right? So that's kind of gives you a picture of the department right now, right? I mean, your senior most leadership, when you think about, again, Goad and DeVos and Trump, you're talking about folks insofar as they have a background or real interest in education that primarily are focused on elementary, secondary, school choice type issues. You got a lot of vacancy in the permanent positions, both among those who would be confirmable and the non-confirmable staff, but in the positions that are above the bureaucrats. You've got a beachhead team that is there, and has some experience, although a limited portion of that really is in post-secondary, and those folks are trying to shepherd along some of the placement. And some of them are able to put very real and concrete and informed ideas in front of the leadership, but again, that's a small workforce. And then you have the turnover even among the bureaucrats and some holdover from folks who might have built a real strong loyalty to the prior administration. So that's your department right now. So where does that leave us? How do we think that this is all going to start, sort of affecting higher ed policy in general? Well, I've said it a couple of times. We think the senior leadership in the administration is probably going to continue to be focused on the issues about which they have the greatest interest. So school choice being a perfect example. That being said, we have seen activity already at the post-secondary level, and some of it not uncontroversial. So the Title IX letter concerning the interpretation of sex discrimination, and specifically indicating that the department no longer take the view that gender was included in the broader notion of sex. There was the executive order concerning HBCUs. There has been and continues to be significant discussion and sort of scuttlebutt, some external, some internal, regarding deregulation and ideas relating to potential downsizing of the department and the elimination of certain posts. And then, of course, a couple of weeks ago, March 6th, we saw the delay of gainful employment deadlines, and we'll talk about that today. So it's not as if there's been no activity in the post-secondary realm, but it is just all to say it is not the focus of the current administration, and at least the folks who are there, excepting the handful of individuals in the beachhead team who have post-secondary experience previously. So what role do we think Congress is going to play broadly going forward? Well, a big one, right? In post-secondary policy, because you don't have that much depth and experience, at least at the moment, in the Department of Education, at, again, the level of the appointees. Of course, you still have a lot of bureaucrats who've been in post-secondary for a long time. But at the appointee level and in their staffs, because there's not a lot there right now, we expect the Republicans in Congress in the near term, and frankly, over the next couple of 3 years, will probably drive higher ed policy, and in a strong way. That's not just because they've got some experience. It's because, again, in Senator Alexander and Congresswoman Fox, I mean, you have two people who are very knowledgeable about and interested in higher education policy and want to get things done, right? And they have the reauthorization of the HEA on their plate. So all of that suggests that they're going to have a really strong hand, where over the last 4 to 8 years, Congress was not as involved, and a lot of higher ed policy was driven directly by the White House. They're seasoned legislators, and they're aware of the significant post-secondary issues. I can assure you all, many of you know this, but for those who may not talk as frequently with folks inside the Beltway, make no mistake that your trade associations and many others are speaking regularly with Congress and Senator Alexander. I mean, my partners who do higher ed lobbying are in those conversations all the time. So these legislators and their staffs are certainly aware of the post-secondary issues that are out there and on the table. And that means those affecting traditional higher ed and as well as career education. Deregulation will be at the top of their priority list. I mean, there have been many statements along those lines and concrete actions to show that they really mean what they are saying and that it is a real concern. Here's just one quote: "Our #1 priority is blocking and repealing Obama administration rules and regulations," and that's Representative Fox. All right, so what about gainful employment? Because that's what we're talking about specifically today. Okay, now that you sort of have that background as to what's going on in D.C., the department, meaning the Department of Education, the White House, could take several steps, alone or in combination. I mean, first of all, they could slow down processes in the allocation of resources. And that's something they can do internally without having to wage any battles. Because remember, I mean, you know, it's politics, right? So every time these guys do something externally, they take an external action, they post an electronic announcement, I mean, they're potentially fighting a battle, or at least indicating that they're ready to start fighting one. And it may or may not be that they're interested in fighting that battle, right? Particularly if there are others of greater concern for the folks presently at the agency. So part of that is the calculation, right? They're weighing their own priorities and deciding how much for them, and again, it's not in a vacuum when contrasted with some of their other priorities, how much of a priority is gainful and how much do they really want to wade into it right now. But something they can do that's harder for opponents to criticize or understand or put a finger on is slow processes internally. And a perfect example of that, you know, a year ago this time, I think it was February 3rd, we started seeing the first communications about completers lists, right? And then we actually saw those completers lists come out June 1st because they were having trouble sort of getting everything moving. But there was still an indication throughout the spring of 2016 that the machinery was being put into place and the wheels were starting to turn, and there was going to be all this data that went back and forth, and all of that, of course, is a necessary predicate to calculating DE rates. And of course, you have to have DE rates calculated before you can make any type of eligibility determination. This year, thus far, we've heard nothing about completers lists or any of that machinery. You know, it is easier for the department if you have people who've left and you're not replacing those people and you're trying to determine how to allocate resources to simply decide not to allocate, you know, significant resources to move that machinery forward at a particular pace, right? So the first thing they can do internally, without making any announcements, without changing the law, but that can be effective in terms of addressing concerns about gainful employment, is to simply slow things down, right? So they might still move forward, but they can slow them down considerably. The next thing they can do is externally they can actually officially delay deadlines, and that's what we saw on March 6th, right, which is good because that demonstrates an awareness of the rule, and for those of you who feel like the rule is something that should be done away with, that the department agrees it at least requires further consideration. Another external action that they could take, which would be even more aggressive, would be to actually officially suspend enforcement. So that's distinct from the first bullet here, which is to sort of internally just slow things down. I'm talking about an external declaration that we are going to suspend enforcement of the gainful employment rule, right? And that would be controversial, and they would get a lot of heat from opponents in Congress and elsewhere if they did that. Finally, and this would be aggressive, but certainly within their prerogative, this administration could initiate a new rulemaking and say, look, we want to go back through the process and we want to reconsider these rules and determine whether they need to be revised. But that, as many of you know, is a multi-month process. I mean, I would expect if the department was going to do this, typically the cycle is they will announce a rulemaking in the fall of a given year. They'll have the negotiated rulemaking meetings in the spring of the following year and then aim to get a draft out in the summer with comments and a final rule out by November 1 of the following year. What that would mean is, even on the most aggressive schedule, you would see an announcement of a rulemaking to revise and rethink gainful employment this fall with the hope that the final reg would go out by November 1 of 2018, which would become effective July 1 of 2019, right? So even on the most aggressive schedule, if they decided to address gainful employment through rulemaking, you would probably not see a new rule, revised rule, become effective until July 1, 2019. Now, they could also do these in combination, right? So they could slow down enforcement of the current rule, they could suspend enforcement of the current rule, and at the same time announce that they're going to start a rulemaking and continue to push out deadlines. They could do all of these things. But just understand that, you know, when you do some of them, it is the current administration taking a stand and preparing themselves to fight a battle. And so there's always this question of, are they really interested in doing that? Is it a significant enough issue for them, or will they take action but in a more passive way? What about Congress? What can they be doing? A couple of things. So funding for most federal agencies expires April 28, 2017. That's of this year, right? So you've got a month and 5 days left before there is no longer any funding appropriated for the federal government, for almost every agency in the federal government. And you may remember there was a piece of legislation that went through last December, and that was what they used just to fund through April 28th. What that means is that the appropriations committees in Congress right now are going to be considering, you know, the different types of legislation that are designed to appropriate funds. In other words, to fund the government for another period of time. It historically has been the case, although last December was an exception, but it historically has been the case over the last 2 or 3 years that we have seen someone attach some type of rider to these appropriations bills, the point of which was to defund or delay gainful employment. That's been one of the preferred vehicles by which typically the Republicans, right, have been trying to get something in there. The challenge was at that time, you had a president that even if they could somehow get a way to negotiate gainful employment into a final piece of legislation with the Democrats, which of course is a big ask. But even if they could work that out, then when the legislation went over to the White House, there was a very high likelihood it would be vetoed or at least not considered, because the signal from the White House was, look, gainful employment, this is a big deal. It's been a major effort on our part. It's something we're very serious about. We've won a couple of federal court battles over it. We're not about to roll on it. So that really took a lot of the wind out of the sails out of the Republicans and made them less interested in trying to fight a battle over gainful employment with the Democrats in Congress, again, because they expected by the time it got to the White House it wouldn't make it anyway. Now that has changed, which means if your Republicans can negotiate something into an appropriations bill that will stick and that the Democrats can live with, if it goes to the White House, that shouldn't be a holdup in getting the legislation signed. The question becomes, then, can they negotiate something with the Democrats? Because remember, the Republicans do not have 60 votes in the Senate. So to get something through, it's going to have to be something they would, in other words, you would need 60 votes to push something through if the Democrats decided to filibuster, right? So the only way that you're going to get something through at this point likely is going to be by negotiating with the Dems. They're not going to want to shut the federal government down, right? Probably not over gainful employment, but there are going to be a lot of issues in play well beyond higher education policy. This is the entire federal government we're talking about. So the question is, you know, how interested are the Republicans in trying to keep gainful employment in when there may be opportunities to get other things that they are interested in if they let go of it, right? Because it's all a part of the bargaining process. It could happen in a couple of ways, though. You could see the rider added to appropriations to bill defunding GE outright. So in other words, they could add language to this bill that just said there's going to be no funding allocated to the enforcement of gainful employment. Alternatively, the rider could say something like, we're going to delay enforcement or delay funding for gainful employment until it can be further considered through the HEA. And that might be something more palatable to the Democrats. So they're not giving up on it entirely. And keep in mind, there are still several Democrats in Washington, D.C., outspoken. Senator Durbin obviously is one of them. Senator Warren is another, who feel very strongly about gainful employment and will not be happy about seeing either one of these options as a rider in the appropriations bill. The last thing, another significant thing that Congress could still do is simply pass on the appropriations bill altogether and try to work with gainful employment in the context of reauthorization, which is a process that Senator Alexander largely runs. This is something I know that Congress, I don't think there's any doubt that gainful employment or anything else that hasn't already been dealt with will be considered in the context of HEA reauthorization, right? The question is, how long does that take? You know, I think it's very optimistic to think that the HEA would be reauthorized even in 2018. You know, I think a more likely target date is 2019. It just takes a lot of time. As many of you know, sometimes it gets pushed out for multiple years before they manage to get everything sewn up. So it'll be interesting to see. So here's the crystal ball, right? Aaron, what do you actually think is going to happen? A couple of caveats. I mean, the first is this is truly crystal ball work. In sort of thinking through things over the last few days, I've had conversations with a number of people inside the Beltway who in turn have been having conversations directly with the White House and the Department of Education and Congress, including Alexander and Fox. So, you know, and all of us agreed, and these folks were the first to tell me, nobody knows what's going to happen. So I do not know what's going to happen, but based on the conversations I've had and the information I've been able to gather, this is my gut. I think that the current administration, meaning the department, is aware of GE, but I think they have other priorities that they are more concerned with, and they are more interested in spending political capital, right, on getting those priorities through. School choice obviously being the number one. And I still think they lack significant post-secondary support. So there are people, again, on the Beachhead team and there at the department who are political allies, so to speak, at the appointee level, right, part of this administration, who know about post-secondaries and have that experience, but there aren't very many. And if you're going to get ready to wage a battle and start a rulemaking you know, all centered around a topic like this, you would like to have more support. So between the fact that they've got other priorities where they are and more interested, I think, in spending their political capital on those priorities, and the fact that there's still so little post-secondary policy support available to the current administration inside the department, I think they're going to slow down processes and the allocation of resources, which, again, is something they can do internally without having to wage a significant battle. And I think they will delay deadlines as needed, consistent with what we saw on March 6th. But I think it is less likely, at least this year, nothing's impossible, but my gut is it is less likely that you will see them do anything that's going to require more political capital, effort, and experience, like initiate a rulemaking or try to suspend the enforcement of gainful employment outright. Meanwhile, I think Congress is extremely aware of gainful. By the way, I also think the folks at the White House are. I mean, I have no doubt that Secretary DeVos has had information regarding gainful employment put in front of her. That's been confirmed. So, you know, but that doesn't change my thinking. Congress is also extremely aware of gainful employment, and I think Congresswoman Fox, maybe to a lesser extent, but also Senator Alexander, don't believe it's a good rule. But they have to contend with the filibuster, and they've got to contend with funding the entire federal government, right? So there's going to be a process of negotiation that they have to go through. I think there will be an attempt. I think there will be an attempt to add a rider to an appropriations bill this time around. It may be that when it comes out of the House, which tends to be more aggressive on these things, it's a defunding of gainful. I think it is far more likely that by the time it gets to committee, if it's still there when it emerges, it looks more like a delay pending further implementation, a delay of implementation pending further review as part of the HEA reauthorization process. But that would be a good outcome, right? Because that piece of legislation is likely going to show up. And remember, the government runs out of money April 27th. So that would be in the next 6 weeks. And if that's stuck, even if you just had a delay pending HEA, that means it is a delay, right? So there would be presumably some sort of suspension of funding, and that would make it even easier for the department not only to slow, but to sort of shut down all these processes moving forward. My primary message, I think, at this point, given all that is in play, is hope for the best, right? Prepare for the worst. And then I'm going to add one that I didn't put on this slide, and I'm going to say, and if you read the blog that we posted last week about the March 6th Electronic Announcement 105, you know, the other point I'll make to folks is mind the details, right? Because even if there's a defunding or a delay, or if the department delays certain timelines, that is not tantamount to the entire law being erased from the books, right? You have to pay careful attention to what exactly has been delayed and what exactly is still in force, and make sure that you are complying with the stuff that's still on the books. And sometimes it may be a little gray, and in those cases I would suggest you reach out to your counsel or somebody else that you trust and talk to them about it. And I'll give you an example. I mean, even if the Department of Congress defunds gainful, meaning we're not going to allocate any more funds to the Department of Education, so they have no money to enforce gainful or push it forward, there would still be a law on the books requiring you to make disclosures to students. And the information you need to make those disclosures, for example, the standard disclosure and the student warning, is already available. So even if Congress were to say we're not allocating any more funds, department, you can't spend any more time enforcing, there would still be an obligation in the law, federal law, requiring you, for example, to make those disclosures. And I think there's some risk if you decide to stop doing it or not to do it at all, that a plaintiff's attorney could come along and say, you know what, this is a violation of our State Consumer Protection Act. There was a federal law that required you to make a disclosure, and you didn't do it. And that should have happened before the student enrolled, and that was tantamount to a misrepresentation under state law. And you can argue all day, well, Congress didn't fund the Department of Education to continue, you know, managing gainful employment. But if I'm the plaintiff's attorney, I say, well, I don't care. There's still a federal law that required that you make this disclosure. So my point is, this is complicated. I'm sorry to say that, because I know folks really would like to just be done with all of this. But it is complicated, and even though there are very positive signs, you know, you've got, if you don't like this rule, I would say, there are positive signs. You've got folks in Congress who want to see it go away and are in positions of power. You've got folks in the White House who are sympathetic, and you're seeing them, through the delay of deadlines, try to take some action to provide relief. But it's not done. and it's not off the books, and you want to continue to be smart about how you approach compliance with this rule. So all of that being said, let's talk a little bit about what the rule has to say and what obligations you've got coming up here. Here's our second secret word, Bruins. Bruins, and that is a bear, for those of you, I didn't know that until fairly late in my life, but that is a bear, I believe. All right, so gainful employment timeline. Here's the updated calendar. The release of the 14-15 final DE rates was January 9, right? And then we saw the disclosure template, that's for the standard disclosures, was released January 19th. That's the thing the department posts online, and you push information into it, and it spits back out the disclosure that you'll use. January 23rd was the deadline to submit a notice of intent to appeal your 14-15 final rates. If you didn't like the earnings information, right, that's the denominator that was used to calculate those rates, you could tell the department, we're going to do a survey or try to get alternate data, and we want the right to appeal. But you had to tell the department you wanted to appeal by January 23rd. February 8th was the deadline to begin disseminating student warnings. I don't mean the standard gainful employment disclosure that everyone has to make for every gainful employment program. I mean, if you had a program that failed, right, if your AY 14-15 final rate was a failing rate, you were required to start making these student warnings to your current and prospective students on February 8th. July 1 is the new deadline. It was March 10th, but it's the new deadline now, July 1, to submit your alternate earnings appeal and to implement the 2017 standard disclosure template, right? I'm just trying to draw a real hard line between student warnings and the standard disclosures because those are very different things. And then I'm marking July and August as the tentative deadline to begin disseminating the student warnings if your appeal wasn't successful. We still don't know. For those folks who filed a notice of intent to appeal back in January by the deadline, so right now you've still got time to do your appeal all the way through July 1. But if July 1 rolls around and you did not file a successful appeal with the department, if you didn't file one at all, or if they made a decision, it turns out it wasn't successful, you know, at some point after that you have to start making the student warnings. We haven't really received guidance yet as to whether or not that would be right away, how long it will take the department to resolve appeals, whether they'll give you another 30 days after you get, you know, the resolution, if you have to start making them to get that up and running. We just don't know. My advice is if you don't have an appeal to file as of July 1, so you know there's nothing for them, there's not going to be a successful appeal because you didn't even get one done, I would, or even frankly, if you don't have a high level of confidence that you have a successful appeal, I would say by July 1 you ought to be ready to go. So as soon as that they get back to you one way or another, you can start implementing the student warnings if you have to. So let's talk about first the standard disclosures. These are the disclosures, again, that everyone has to make come July 1, right? So, well, that's the first slide. When do you have to start making the GE disclosures, right? The template was released on January 19th. Just saw that on the prior slide. July 1 is the revised date by which you have to start making the disclosures. What information has to be disclosed? The precise combination of information that has to be disclosed is determined by the department and is reflected essentially in the template that they release each year. And I thought this was sort of an innovative way they went about this in the regulations. Historically, they've said these are the 10 things you have to disclose. This time around, they said, we can require you to disclose any one of, say, 20 things, right? And we may change up the exact combination that we want you to disclose year over year based on changes in, you know, in the industry or the environment, feedback we get from consumer testing, things along those lines. So they created a mechanism that gave them a little more flexibility. The disclosures are based on data reported by schools and in some cases on data calculated by the department. At least that's the way it should work. Now, we'll see in a few minutes. This year, it's almost entirely based on data that you all are providing. But in the future, depending on how things turn out, it could be that it would be a more even mix of data that you're providing and inputting into the template and data that when you bring up the template or insert your OPID is automatically populated because it's based on calculations the department made. So we have a graphic here. Here's the idea. This is all the stuff that you've got to include this year in your 2017 disclosures. And remember, really what happens is you bring up the disclosure template and it asks you questions and you push information into it. In some cases, it calculates using information you've input into the template. It will, create some of these numbers. But at the end of the day, when the actual disclosure is generated, right, this is the stuff that's going to be in it. The blue items are items that you already have been disclosing in your existing gainful employment disclosure templates. However, the ones ringed in red have changed a little bit. The orange items this year are brand new, right? So that sort of gives you the overall sense of what's old and what's new. And I'm going to go through now sort of the individual where there have been changes. Normal time completion rate. So there's no 150% completion rate statistic that you're providing, or 150%, sorry, 150% of normal time completion rate that you're providing this year. So you're just providing a normal time completion rate. It's based on the most recent cohort of students for whom sufficient time has passed for the cohort to complete the program within its scheduled length. The significance of that is that means that the exact cohort you will be using will vary depending on the length of your gainful employment program, right? Because if it's a 4-year program, then you're going to have to go back further to get to the cohort of folks who've actually had time to complete the program. If it's a 1-year program, then you're going to have a cohort that came along much more recently. And if you've got a variety of programs, what that means is for each template that you do, the grouping of students that you're looking at may change a little bit, right? Because again, it's tied to the length of the specific length of that program. Median loan debt for completers. So this is going to be calculated by institutions this year. And the big difference is you're now combining all forms of debt. So you remember in the old days, you were asked to give a median Title IV debt, a median private loan debt, a median institutional, charges debt. I believe that was it. But at any rate, you were asked to give median numbers in different categories. I suspect, and this would not surprise me, that some of the consumers that they talked to said, it's not helpful for us to have all this broken out. We just want to know at the end of the day, what's the debt, that we're likely to walk out of here with, whether it's private or federal, it doesn't really matter to us. So the department said, let's make it simpler. We're just going to give them one consolidated median loan debt number. And then using that median loan debt number, the template will calculate a monthly payment amount, assuming a 120-month amortization period, right? So they're assuming a 10-year repayment schedule, basically. And then they're going to give the students, I believe they also will give them that monthly payment amount. And, of course, they try to put it in very accessible language. So they say something along the lines of, students in this program typically after they graduate have to make a payment in this amount each month. Right? These metrics may be calculated by the department in the future because, as you probably already are thinking to yourself, well, gosh, we provide all this information every year as part of our reporting obligation on October 1st, right, or before, relating to our gainful employment programs. Why can't the feds just generate this data? Well, they could, and they really just ran out of time last fall. So that's why they've asked schools essentially to do the calculations and input the information. And then their form, meaning their web form, is just doing a little more calculation to spit back out that monthly payment amount. The percentage of students receiving Title IV, right? So this is the one metric in the disclosure template that takes into account non-Title IV students, right? Because you can't tell the percentage of students, you can't calculate how many students got Title IV without knowing how many didn't get Title IV. Whether or not your debt to earnings rate failed in the prior year, right? And if it did fail, then that means your template will automatically sort of convert into the student warning, and it will include this language for students, and we'll talk about that later. Median earnings for program graduates. So this is the information that the department has obtained from the Social Security Administration, right? So this is something that they went and got, and now you have, and they're asking you to include in the disclosure template for students. Licensure and certification. So you all, if you've been thinking about gainful employment much over the last couple of years, and just in general, licensure and certification has become a bigger issue for the department. When you make gainful employment certifications, or your CEO does, every time you update your e-card, there are certification statements you're making relating to the licensure, certification opportunities for your programs. And the real end of day here thing is, they want to make sure if you're offering a program that produces graduates that have to get some sort of licensure to do whatever it is they're training to do, that your program adequately prepares them to do that. So they can sit for that license, in other words, based on graduating from your program. They are asking you to speak to, and the template is going to include information relating to licensure and certification, specifically whether the program satisfies educational prerequisites for professional licensure or certification in each state within the institution's MSA. That's the metropolitan statistical area. And when you go through, click through the disclosure template, if you haven't done it yet, there actually is an option where you can click and it will tell you your MSA. So you can figure out what MSA your school's in and which states are within the MSA, right? Usually it's sort of a big blob around the immediate city or smaller metropolitan area. Or any other state for which the institution has made a determination regarding such requirements. So if you have a small cosmetology school located in the middle of Iowa, this is probably not a big concern for you, right? I mean, you know the certification guidelines, and most of your graduates probably stick to the region and are in one state. But if you run a program like Farm Tech and you're in Memphis, so that you may have in your metropolitan statistical area not only Tennessee, but Missouri and Arkansas and Mississippi, this is going to be a more complicated exercise for you, right? Because you're going to need to know, at least for the states in your MSA, whether or not your graduates are going to be able to sit for whatever kind of licensure they need to have. And then in addition to that, you're going to need to speak to, again, any determination you've made for any other state outside your MSA. Finally, there is just a canned statement built into the disclosure template that basically says we've not made a determination for any other state, right? Because remember, you're speaking to the ones in your MSA and anyone else you've made a determination, or any other state for which you've made a determination. And then finally, there's just this additional language that basically says, and we haven't looked at any other state out there. So that you know, though it's not required this year, the department could require that you include any of the following content in disclosures in future years. Now, you've got a friendlier department right now, and it seems unlikely that they're going to expand things, particularly given all the discussion we had earlier. It's hard to imagine they would allocate resources, assuming Congress even gave them resources necessary to do all of this. But under the law, it would be possible next year that the department could also require you to include in your standard disclosure withdrawal rates. Those would be federally calculated withdrawal rates pursuant to a federal formula, 150% normal time completion, loan repayment rates, program cohort default rate. So that did not go away. It's no longer a part of the eligibility scheme in gainful employment. It got booted back during the final hours leading up to the 2015 rule, but there is still a whole process in place in the gainful employment regs for calculating program cohort default rates, and you could be required to disclose them. Median earnings for withdrawals, median loan debt for withdrawals or drops, and then the link to the College Navigator. I think it's kind of funny that the department, and this is just a side comment, did not require on the disclosure template that you include the link to the College Navigator website, right? Because the difficulty of doing that is pretty much zero. All of these others, I will tell you, my belief is the main reason that all of the other components weren't required this year is because they would all require that the department do a bunch of calculations. And under the law, for example, program cohort default rates, if the department requires you to disclose those in your disclosure template, then it has to calculate them, and it has to send them to you, and you go get a chance to look at the data. Much like the completers list and the alternate earnings appeals, there are these mechanisms with regard to PCDRs where you get to review the underlying data and challenge it, et cetera. And the department just ran out of time. They did not have time in fall of this year or last year to calculate all this stuff and push it back and forth with schools and go through all those required piece steps. So they just didn't require that it be disclosed this year in the disclosure template. That was the easy out. But the link to the College Navigator, I mean, all they had to do was say include the link. In fact, they could have just put it in there themselves as a part of the template, and they didn't. And what that really suggests is they don't have a lot of confidence in that website. Which is too bad given how much time schools have to put into producing and reporting data that's used to populate that website. When and where must these standard disclosures be disclosed? Okay, so some of this is similar to what was required in 2011, but it's worth emphasizing again, and it is still the law. On any school webpage containing academic costs, financial aid, or admissions information about the program, maintained on or on behalf of the institution. So look, if you've got a front page that doesn't speak to any particular program, and it's really just an advertisement for the school, or you've got certain pages that may talk about financial aid or something like that, but maybe not specific to the program, it may be that you do not need to have any information about or a link to the disclosure template, right? But on the program page or on any other page where the program is specifically discussed, the expectation and the requirement under the law is that you will have a link to the template. The other thing is, if you've got a third party with which you contract and they build websites or otherwise market or promote on your behalf, right, and they are putting microsites and things like that up there about the program, they're also supposed to be including a link, right? And there are people, or were historically at the department, who were looking at this kind of thing, and it most certainly is reviewed in the context these days of program reviews and even some substantive changes. If you go through a change of ownership, you can bet that one of the things the department looks at these days, the reviewer, is your gainful employment disclosures, and they want to make sure they're on your website and that they're in the places that they need to be. So if you haven't thought about this in a while, it is time to take a hard look at your website or any other website someone's maintaining for you. Just make sure you're in compliance. This is still in the law. The school should also disclose the template for that program. The way it should be disclosed, it needs to be prominent and readily accessible, clear, conspicuous, and direct. So the link needs to be direct. A question I get not infrequently is, well, we have one page where we put the links to all our programs, right? So if you go to any program page or, you know, in our advertisements or our marketing, what we have is a link that takes you to that page, and then you have to scroll through and find the disclosure, the link to the template. Look, I'm here to tell you, I mean, whether the department writes you up or gives you too much grief over that is one thing, but it is certainly not compliant with the law or their expectation. I mean, that has been made readily clear to me over and over in various different events when I've been working with institutions and talking with the department. The expectation is, you know, on the program page or in the advertisement or in the marketing materials, that the link that appears there will be a direct link to the template. So you click it and the template comes up, not that you would have to go through 2 or 3 pages. In all marketing and promotional materials, so I was talking about the web page on the prior slide, but also marketing and promotional materials made available by, again, or on behalf of the school, by a third party, for example, to prospective students that identify the GE program by name or otherwise promote it. So again, if you're driving down the street and there's a giant billboard and it's just got the, you know, the name of the school and it says, "Be a Bruin," right, and it's got a big bear, or in our time in St. Louis, "Be a Billiken," right, that's St. Louis University. You do not have to have a link to any gainful employment disclosures, right, because that's not about any specific program. That's just school branding, right? But if you have a billboard up there on the side of the road and it says, "Come check out our amazing culinary program or medical assisting program," or what have you, and that's a gainful employment program, there is an expectation that you would have, and I know it sounds crazy, but that you would have the link somehow represented on that billboard. And you say, "Aaron, that surely you don't actually mean on a billboard on the side of the road." So, and this is right out of the law. Examples of marketing or promotional materials include, but are not limited to, catalogs, invitations, flyers, billboards, and advertising on or through radio, television, print media, the internet, and social media. Again, that's not guidance from the department. Back in 2011, they issued some guidance that looked like this. But when they put the gainful employment rules out in 2015, the new ones, this was actually baked into the law itself. So, yeah, I actually do mean a billboard on the side of the road. Now, you know, there's still the question of risk. What is the likelihood that someone from the department's ever going to call you? I have had a client that got a call once from a regulator who was driving down the street and saw a non-compliant billboard. Different matter, not gainful employment, but it does happen. Or a competitor might give someone a call. Unfortunately, that happens occasionally as well. You're going to have to decide on the risk and how seriously you feel like you need to comply with the letter of the law. But what I will tell you is that the letter of the law is clear. There is no doubt that the expectation is that this data, right, will be represented on billboards and this wide array of marketing materials. On web pages or in promotional materials where the space airtime constraints preclude using the entire gainful employment disclosure template, schools may use a prominent, readily accessible, clear, conspicuous, and direct link. The implication here, by the way, is that on a website where you don't have a space or airtime constraint, the template would actually be embedded on the page, and you wouldn't even have to click on a conspicuous and direct link, right? So think about that too, but I will tell you my experience has been in most cases the department is okay if on the program page and in places like that, the link is there and you click it and the template comes up. I haven't seen them give schools too hard a time. Schools must identify the link as, quote, important information about the education, debt, earnings, and completion rates of students who attended this program. So there used to be slightly different language that the department back in 2011-12 had introduced in some guidance, and a lot of schools put that all over their websites and whatnot. The new law, which went into effect January 1, 2017, this new disclosure law, has this new language. So if you have not gone back to these places where you reference your gainful employment information, this is the canned language you really ought to be using. Schools must disclose the standard disclosure directly to any prospective student or third party acting on his behalf, so if mom or dad show up, right, before the student signs an enrollment agreement, completes registration, or makes a financial commitment to the institution, right? So this is a little different too, right? We now have this requirement. A lot of schools started doing this anyway, and in some cases there were state laws that sort of piggybacked on the gainful employment disclosures and put requirements like this into place. Illinois is a perfect example. But now federal law actually requires that you start handing out the gainful employment, the standard disclosure, before the student enrolls. For most career schools, you've actually got an enrollment agreement, but for nonprofit institutions that have no enrollment agreement but have gainful employment programs, you're going to have to think about what they mean in terms of completing registration or making a financial commitment. So how can the new GE disclosures be delivered to a prospective student? Because this is all pretty tightly prescribed. They can be delivered in writing, right? In fact, they must be delivered in writing. You can hand deliver them as a separate document. So, you know, during an in-person meeting, for example, on campus, I would think most schools would probably do it in the context of an orientation or initial meeting there on the campus, unless they're doing it electronically, and we'll talk about that in a minute. But you could also do it as part of a group presentation. But remember, it has to be before they sign the enrollment agreement. Most of the career schools I work with, it's going to be unusual that you're going to have a group of prospective students together and be sort of taking them through an orientation before they've signed enrollment agreements or gone through that part of the process. So probably it's going to be on an individual basis. And you have to obtain written confirmation of receipt. Now, I haven't seen a lot of guidance as to what exactly that means. The easiest way to do that is probably to have them sign the disclosure somehow. But you could have a secondary document. I work with schools and almost always recommend the use of a pre-enrollment checklist, where you have, you know, line items, and each line item represents some document that you're giving them in advance, and you ask them to initial that they received it and then sign at the bottom that they got all those documents. I think that would probably work too. I don't know that you have to have them actually sign the face of the disclosure, but I would keep a lookout, see if the department provides any additional guidance on that point. You can deliver it via email, and certainly for online institutions, this will be important, to the primary email address used by the institution for communicating with the prospective student. If you need to send it via email, you have to comply with some specific distribution requirements. And again, I just want to emphasize, this is all in the law. This isn't sub-guidance that the department has offered up. I mean, this is in the letter of the regulation. So the special email distribution requirements are as follow. You have to ensure that the disclosure template is the only substantive content in the email. So if you're using some sort of if you're an online institution, for example, or another institution that uses some sort of electronic signature software or third party where you will send someone an email and it'll have 20 attachments, right? I don't think that works here. I mean, they are suggesting that the disclosure needs to be in its own email and needs to be the only substantive content in that email, right? They need to receive, the school needs to receive electronic written acknowledgement that the email was received. I'm going to talk in a minute about what that means. There has been some guidance from the department. You have an obligation to send the notification using a different address or method of delivery if you get a failed delivery response. Okay, so this is pretty specific, by the way. This doesn't mean if you get no response necessarily you have to immediately do that, but it does mean if you get a failed delivery response. And you have to maintain records of your efforts to provide the template. Now, I think you want to actually maintain records that you're trying to provide the template to all students, even those who don't eventually become enrollments, because the department's going to want potentially in an audit or program review setting to see that you're, in fact, providing it, you know, as a matter of course, right? And if you don't have any record that shows that you're providing it to all of these individuals and you only have records for the folks who actually show up, you know, there could be some question from the department. That's something, again, I'm hoping to get more guidance and clarification from in the future. But for the moment, I would assume that you want to keep, you know, the record of that email being sent to all prospective students and have that note in whatever your student management system is or whatever, so that you can show that you're consistently satisfying this requirement, whether they enroll or don't enroll. The other thing is, I've had folks ask me, well, you know, what if we can't get to them via email or whatever, can we still enroll them? Well, here's the thing. I mean, the requirement is you have to make the disclosure before they enroll. And I think you're going to have a hard time arguing to the department that we were able to enroll a student and take their money and start teaching them, but there was no opportunity to give them the disclosure, right? I mean, think about it. The department's going to say, wait a minute. Okay, maybe the email address was bad. Maybe they didn't respond the first couple of times. But you clearly are successfully communicating with the student because they've enrolled and you've got their money and they're participating in a class. So there had to have been some point prior to enrollment where you could have figured out a way to get this disclosure to them. I mean, I think playing devil's advocate, that would be the argument. And I think it's pretty hard to defend, frankly, or to overcome, I should say. So my advice would be I would plan to have the written confirmation of receipt from each student before you enroll them, and I would just make it a requirement. I think if you enroll students and you don't have on record the written receipt, that you're exposing yourself to findings, program reviews, and things like that. Okay, so I know there's a lot of text on the page, but the department's offered 3 pieces of guidance relating to the disclosures. This is on their FAQ page, and I checked today, there's nothing new, but they're all of interest, so I just put them here and I wanted to walk through them. First of all, how can schools fulfill the email verification requirement? Because I've gotten this question a lot too. The good news is the department's suggesting there's some flexibility. Institutions should use a method that verifies the student or third party has read the message, whether it is a passive or whether they must click to confirm receipt, right? So an email read receipt would be acceptable, or the institution could have the prospective student or third party physically or electronically sign a statement that they've received their disclosure template, include a link at the bottom of an email that they would click that would indicate receipt. But, and this is in the red, and I added the red, regardless of whether the disclosure was hand-delivered or emailed, the institution should verify documentation of the prospective student's receipt of the disclosure template before allowing the prospective student to sign an enrollment agreement, et cetera. So they're repeating this idea that you have to do this before you let them sign enrollment. And I don't know exactly how it's been handled because it's never been done before, but I think there's a risk if you went through a program review and you didn't have this, they might say these students weren't eligible, or you should never have enrolled them and you've got to pay all the money back that you took in on their behalf. I mean, that would be a worst case scenario, but I don't think it's beyond the pale. So I would make sure I get it done. The good news is, an email read receipt's a pretty low threshold. Right? It's a lot easier than having them affirmatively click on something like a link and go to a website or even send you an email back or sort of have to write or sign anything. So there's some flexibility from the department, at least on what would be required. I'll get to the other 2 questions, by the way, later. But first, I wanted to actually show you a copy of the new Gainful Employment Disclosure Template if you haven't already run things through, just to see what it looks like. It's pretty neat. It's modernized a little bit. Doesn't look too bad. But you can see the department, again, they're sort of making this effort to make the language very accessible, colloquial. I don't have a problem with that, except where I think that it paraphrases or is so colloquial that it doesn't really give all the details and may be a little misleading, and I think sometimes that is the case. I will let you go through this slide at your leisure when you get the slide, but it sort of gives you a sense, even without having to go through everything and fill something in, of what it looks like. The main thing I wanted to focus on, I just had to do it in 3 parts because it's kind of a long disclosure. At the bottom, and I blew this up, this is typically pretty small, but you will see at the top, there is an opportunity to provide additional information, okay? And the one thing that I try to point out to my clients is when you have a disclosure that is prescribed, meaning, you are forced to present certain types of information in certain ways, and the financial aid shopping sheet's another one I don't like very much. you should take advantage of any opportunity to provide explanatory information or contextual information, right? So if you feel like when you look at some of the language here, if it says something like, you know, the average student owes X, and you think for whatever reason that's crazy, that doesn't make sense, the numbers here are having to be calculated in a way that's confusing, this is your opportunity to try to address that, right? And, you know, it can be a challenge, especially if it's a complicated issue, but just remember, you do have a chance to add notes, and you could train your admissions staff when they go through this, if they feel like there's a number on there that's damaging or not really accurate or representative. You know, you have this language down here in the additional notes. They can use that and go right to it and say, look, I just wanted to, you know, you may see this, but I wanted to note X, Y, Z, and they can, you know, go down to that additional section and draw the student's attention to. So it's an opportunity is really all I'm trying to say, to add some explanatory language and take advantage of it. Okay, the Gainful Employment Disclosure Template asks you to enter the median earnings most recently provided by the Department for Program. Where can I find my program's earnings? Okay, so you all know earnings data returned by SSA, right, can be found in the FSA Data Center, and the department actually made it public, right, and they posted a spreadsheet. Because the debt to earnings rates were only calculated for programs having at least 30 completers in the applicable cohort period, and earnings data was returned by SSA for programs having at least 10 completers in the applicable cohort period, you may have earnings data for programs that did not receive DE rates. And this is the point. This is why I included this slide, because I wanted to really emphasize this. So just to reiterate, right, if you didn't have at least 30 completers, the department didn't calculate DE rates for you. And a lot of people sort of have that in their mind. Yeah, we didn't have any DE rates this year. But if you had more than 10, you might still have an earnings number, right, and it would be on that spreadsheet. And here's the point. I've got it in red. You are required to list this data if it is provided. So please keep that in mind. Even if you didn't have a DE rate calculated because you only had 20 students in your cohort, you may still have earnings information that was made available by the department, and their view is you are still obligated to include this in your disclosure template, right? If your program has an alternative earnings appeal pending, you should answer the questions on the disclosure template regarding earnings, and you may not have to provide the data right away. And there's a checkbox you can mark that says, check here if the department has not provided earnings data for this program at all. So there's some nuances there. The other thing I just wanted to point out, because if you haven't seen this guidance, you might, if you're going through the template, remember I mentioned earlier, the department takes that median loan information that you provide. You have to calculate the median loan debt information, that sort of consolidated debt number, and then they want you to put it into their worksheet. And I told you it calculates an annual loan payment, and then it spits it out into the template and says, hey, this is the kind of loan payment most of our graduates have. And I mentioned that what the department is doing is they are amortizing that median debt over 120 months, right, 10 years, and that's how they're coming up with that annual loan payment. Well, to do that, you also need an interest rate. And I could not believe when I went through the template that it actually says, put in the applicable interest rate. I thought, no one's going to know this interest rate unless you're someone like me who spends a bunch of time calculating all these numbers. But most people probably would look at that and say, well, where the heck am I supposed to get it? And the thing is, it's not just a number you can pull off the web. There's actually calculation that has to be done. To get the right interest rate, you actually have to average 3 interest rates over 3 years that applied in the past. So I thought it was kind of crazy that they had this question. And so I was very gratified to see that they included in the facts section, although many of you probably haven't seen it. It's not as if all of us visit every day. But they at least said the correct interest rate is 6.8% for all programs, right? So when you get to that question on your disclosure template, rest assured, the right answer is 6.8%. In future years, I hope the department will continue to provide interest rate information because there will come a point where it won't be 6.8% for every program, right, if gainful employment sticks around. And just keep that in mind. Okay, here are your resources relating to the disclosures. You can see there was a fair amount of information that was provided in late last year and early this year. That was the December 16, January 6, and January 19 electronic announcements. And then there's the March 6th announcement, right, which delayed the disclosure requirements for the standard disclosures to July 1. And then the last thing I've included here is just the link to the Frequently Asked Questions website because they are posting periodically information there that can be useful, like the questions we went through earlier. Okay, student warnings. Here's the last secret word, Boilermakers, right? So Bruins, Bulldogs, and Boilermakers. There's a theme there. I'm sure someone out there has picked up on it. So when does a school have to begin making the GE warnings? This is a really important point. So February 8th, we talked about this earlier, February 8th was the deadline to begin disseminating the student warnings for programs that had a failing AY 1415 final DE rate. So let me say, if you were in the zone, you do not have to make student warnings this year for a program that was in the zone, and you certainly don't have to make a student warning for any program that passed. But if you failed, even just year one, you're required to start making a student warning, because under the law, you have to make student warnings anytime you could potentially lose eligibility when the next round comes, the next set of rates come along. And if you failed once, it is possible you could lose eligibility the following year, because 2 years failing, right, leads to ineligibility. So February 8th was the deadline to begin making those student warnings, unless you filed a notice of intent to appeal by January 23rd. Okay, so if you're listening today and you had a program, a G program, that had a failing rate first year, and you did not file a notice of intent to appeal, you had an obligation to start making your student warnings, which we're going to talk about in a minute, as of February 8th of this year, right? And we have confirmed, and I also want to make this very clear, we have confirmed with the department that Gainful Employment Electronic Announcement 105, which delayed the standard disclosures to July 1st, did not affect this obligation to begin making student warnings on February 8th, right? So if you're in that group that was required to make warnings on February 8th, nothing about Electronic Announcement 105 changed or stopped or withdrew or paused in any way that obligation. I just want to make that real clear, because I had some people who called me and said, oh, we don't have to make the student warnings anymore. That is not the case. And if you read Electronic Announcement 105, you'll see it doesn't say anything about student warnings. I'm not suggesting there's no way it could be construed to potentially get there. I understand, I've read it, and it is possible someone could come up with that interpretation, but what I'm telling you is that is not the department view, and it was clearly not their intention, and I've had that confirmed for me. The deadline is unclear to begin disseminating the student warning disclosures for programs that do not file an actual alternate earnings appeal by July 1. What I mean is, and I spoke to this a little bit earlier, if you did file a notice of intent to appeal, so you had a failing program, you did file a notice of intent to appeal, right? So you do not have to make the student warnings right now. And then you get to July 1 and you don't actually have an appeal to file, or you couldn't get north of 50% or what have you. It's not clear when at that point you'll have to start making the student warnings. But remember, my advice was I'd be ready to go as of July 1 because it seems like it would be pretty easy for the department to rapidly determine next day who didn't even file an appeal, right, and to immediately get a letter back to them and say, okay, you got to start making student warnings, and you don't want to be caught off guard. What's the content of the GE warnings for prospective students? And one thing I'll highlight here is there are different requirements for prospective students and current students. And whereas your obligation with regard to the standard disclosure, you are only obligated, and you got to put it all over your website and your marketing materials, but you're only obligated to physically disseminate it to prospective students. You don't have any obligation to send all of your current students a copy of the standard disclosure. But when it comes to student warnings, you do have an obligation not only to start providing it to prospective students, but also to start providing it to, or to provide it at least once to all of your current students. And what you have to provide exactly differs a little bit with regard to prospective and current students. Okay, so we're going to talk about prospective students first. The G warnings for prospective students have to include a link to the College Navigator website, the verbatim disclosure set out on the next slide. This program has not passed standards established by the U.S. Department of Education. The department based these standards on the amounts students borrowed for enrollment in this program and their reported earnings. If in the future the program does not pass the standards, students who are then enrolled may not be able to use federal student grants or loans to pay for the program and may have to find other ways such as private loans to pay for the program. This is right out of the law. You have to include this language. It's not as bad as it could have been. I mean, they at least qualify and say if it doesn't pass, you may not be able to use federal funds. So they don't use certain language here. They use qualified language, which is good. Unfortunately, the way it appears in your disclosure template is probably not going to go over well with prospective students, right? So this is what happens to your disclosure template, the standard disclosure template, which you can use in part to satisfy your student warning obligation. When you input into the standard disclosure template, the GED template, that your program had a failing rate, this is what happens. This thing pops up and it automatically inserts that canned language, and you have this big red thing at the top, right? So if your plan is to continue enrolling in this program, understand that this is clearly going to have an impact on enrollments, and you're going to want to give some very deliberate thought to how you're going to present this to students and how you're going to package it. Let's talk about timing, because the timing requirements surrounding the giving of the student warning to prospective students are a little wonky. It's not a specific time. What you have to do is sort of comply with 3 different timing requirements. First is timing rule 1. You have to provide written or oral the warning in a written or oral format to prospective students or to a third party acting on their behalf, again, mom or dad or their sister if they called, at first contact about the program. And that doesn't necessarily mean about first contact about the school. So if somebody calls you generally to talk about the school, you know, it's possible you could have a conversation with them that wouldn't trigger this requirement. But in most cases, my guess is the first time someone talks to a prospective student, they are going to talk about specific programs and potentially the program that student will end up in, which means if one of them has a student warning requirement attached to it, you've got to, in writing or orally, make that student warning at first contact, right? And this has to be carried out by third-party marketers if they're having first contact with prospective students on your behalf. By the way, I'll just say as an aside, if that is the case, I would look hard at the contracts that you have with those third parties that are doing this kind of thing on your behalf, and I would include and have them agree that they will make this disclosure and also include some form of indemnification if they fail to make it, and as a consequence you end up with some form of exposure, right? Because you want to protect yourself if someone's responsible for carrying out this obligation on your behalf, okay? But the first thing is you got to figure out how to make sure if you're going to continue enrolling in a program that has to make student warnings, how you're going to satisfy this first contact rule. Now, you have the obligation, again, to do it orally or in writing, but between you and me, it seems like trying to make that entire disclosure orally would probably be difficult, right, because there's a lot that has to go with it. It may be better to just give it to them in writing up front. The other thing is, if you do give it to them orally at the first contact, you're still going to have to come back around and give it to them in writing later, right? But if you give it to them in writing at first contact, it is conceivable that you will not have to make the disclosure a second time. So that's something else to consider. So the second timing rule, you have to provide the written GE warning to the prospective student. So in the written format, has to be done at least 3 days before they enroll, register, or enter into a financial commitment with the institution, okay? So if, let's say you do it at first contact and in writing, okay? And then you set an appointment and they come in 10 or 15 days. You're okay, right? Because they received it in writing at first contact, okay? And that was at least 3 days before they are there for their appointment and signing the enrollment agreement. So that works. On the other hand, if you make the disclosure, the student warning originally orally, then when they come in or at a later date, you're going to have to provide it in writing. And if you wait to provide it in writing when they come in for their appointment where they typically would sign an enrollment agreement or make a decision, you're going to have to send them home, right? So you're going to want to think about how to integrate these requirements into your admissions process in a way that makes sense so that you're not making the same disclosures over and over and over. The third timing rule is if more than 30 days have passed from the written GE warning being received, then you have to provide it to them a second time, and you have to wait another 3 days, right? So you would really like to try to orchestrate it so that you can make that written warning at first contact, and then you can get through the admissions process before the 30 days lapses. Otherwise, you're going to have to make it a second time, and you're going to be subject to a second cooling period. All right. How may the GE warning be delivered to prospective students? Again, orally, by the telephone, but that only satisfies the first contact rule. So if you do it orally the first time out, you're going to have to make it in writing later. You can hand deliver it as a separate document, once again, individually or as part of a group presentation, much like the standard disclosures. And you can use the template. That includes the warning language to satisfy the requirement. You have to update the template, by the way, within 30 days after receiving notice of the loss of eligibility for the program or a fail. And effective 1/17, institutions are already required to provide the disclosure template to prospective students via hand delivery or email. And again, finally, you have to obtain written confirmation or receipt. You can also send it via email. So let's say you have first contact and you have them on the phone. and you need to get this to them. I mean, you could email it to them right then if they give you an email address, but if you do that, you have to satisfy the specific email requirements, which are identical, right, to the ones that you saw earlier relating to emailing of the standard disclosure. Has to be the only subject content in the email. You have to get acknowledged written receipt. That could include a read receipt, right, but you have to have something. And you have to maintain records of your efforts to get that email out there. Also, if for some reason you can't get to them via email, you can use other delivery methods to back up. Okay, so let's talk about current students. What's the content of the GE warnings for current students? In this case, again, you have to include the GE Navigator. You have to include that verbatim disclosure, right, the canned language. You have to indicate, though, also a few other things. Whether the institution would continue to provide the program without Title IV, so students could complete the program, whether the school would refund any tuition fees or other required charges already paid if Title IV eligibility was lost. You have to describe academic and financial options that are available to students to continue the education, maybe in a different program at the school. So let's say they're, you know, in a diploma program and you also offer an associate program that's stacked, so you know the diploma medical assisting flows into the medical assisting associate degree program. You could tell students, look, if the diploma loses its eligibility, you can transfer into the associate degree if that would be of interest, right? And all your credits would move over. And you need to explain whether students can transfer the credits to a different institution or somewhere else. You know, some schools may look at this as onerous. I see it as an opportunity, right? If you're going to have to make that warning to current students, and what you're probably going to do is provide them the disclosure template, right, with the warning information in it. You hand that to current students, you're going to want to, if you can, also provide them information that provides some assurances, right, or helps them understand if there are other opportunities, you want them to know that. So, you know, if you can make it work for them without federal financial aid, if you've got private loan options or something like that, if there is an easy transfer into another program, if you offer the same program on the other side of town at another location, you know, you'd want to let them know that, assuming it's not in danger over there if it's passing, you know. But this is an opportunity to try to build some context around the required disclosure and potentially soften the blow, right? And it's the same point I made earlier when we were talking about the standard disclosures. And I said, you know, you've got this space at the bottom where you can editorialize, provide some additional context. You know, use those opportunities. Don't see this, I would say, as a burden. See this as an opportunity to provide information to the student of interest, right? That may as a result, give them comfort that staying in the program is certainly a good idea. So how can the GE warning be delivered to current students? This is the same mechanic, right? You've seen this with the standard disclosure and with the requirements relating to prospective students. You can deliver it in writing, you can hand deliver it individually or part of a group, you need to obtain written confirmation or receipt, or you can send it via email. And if you do, you have to comply with these special email distribution requirements, and we've already been through these, right? So that's it, TC Resources. This is our blog, Regucation. If you're not on it, let me know. We have a distribution list, by the way. I sometimes fail to mention this. We will email out folks and let them know when we have webinars or we have blogs. I assume most people on the webinars have that information or part of our list, and that's how they knew about this one. But if you're not and you would like to know when we have a new blog or webinar going up, shoot me an email and we'll add you to the list. We write about a lot of things, including gainful employment. Decoding the final borrower defense rule. So we do a lot of webinars, and this was actually one we did last fall, a 5-part series. Sometimes we'll do more in-depth series. And I will just, as a total aside, say that as of right now, borrower defense has not yet gone away. And there's not been any activity in Congress to try to kill it with some sort of Congressional Review Act piece of legislation. So it looks like borrower defense may, in some form or fashion, be around for a little while. And we'll probably be writing and talking about that more in the coming months. We'll sort of look over at the questions. Can you speak more about the length? For instance, if we're an institution with primarily non-traditional students who may take 3 to 4 years to complete an associate's degree, do we just use that period even though our published completion time on our ECAR, for instance, is the number of weeks based on full-time enrollment? Yeah, so I'll say a couple of things here. One is I've been getting a number of questions, and I do think there are some decisions that schools are going to have to make, either reaching out to the department or just using their best judgment about some of these time periods and, you know, what cohort of students you want to use. But my take here is when they talk about, you know, the cohort, it really should be based on what I'll call normal time completion, and that is what's published in your catalog and presumably what is on your e-course. So even if you have non-traditional students who may often take more time, that's still not what I think the department is contemplating. I do think that they are contemplating that you will use your published normal time and sort of make your decision as to what the most recent available cohort is based on that published normal time to graduation. For the disclosures, but I will just go back and say, but I acknowledge that there are some odd wrinkles that are coming up. Like I said, I don't want to get into all the variations, but I've had a couple of 3 people call me and some good conversations where people are dealing with some real oddities about trying to figure out some of these cohort questions. For the disclosures, what years are we looking at to populate the fields? It sounds like some will be 2015-16 data, some 2014 data, some going back further. Confusing. Yeah, it absolutely. So you've hit it on the head. It varies depending on the data that you're disclosing, right, what the cohort will be. And in some cases, it's information the department has calculated using a particular cohort. When you're talking about, you know, your DE rate, for example, you all know how that process works, or we've talked about that before, and you've got specific cohorts there. And then when you talk about completion rates, it's a totally different cohort. Unfortunately, a lot of that is not particularly transparent to a student, right? So I agree, it is confusing. And I think schools are going to, you know, I would talk to your trade associations, your reps, whoever, and try to get back to the department and ask for some clarity and some guidance and some resolution in for some of these things. The good news is, because I know I say that and people roll their eyes and think, oh, well, sure, that sounds easier said than done. The good news is there are people there at the department now who are more willing to listen to inquiries and concerns from this sector than was the case in prior years. At least that is my personal experience, and I believe that to be true. So I think if you could ask your third-party servicer for clarity. I know some people have, and I've had conversations with some of those third-party servicers. But you're right, you've got a range of cohorts being used, and it depends on the type of information that's being disclosed. Let's see here. What about in programs where licensure is optional, like massage therapy? Okay, so that's, you know, we were talking about earlier, one of the disclosures that's new this year relates to, you know, certification requirements for programs. You know, if you want to play it conservative, maybe you try to provide information about popular certifications that may not be required. I don't think that's a bad idea. Certainly you want to know that information as an institution, but when you're talking about what's legally required, my take is that the department is referring to programs where licensure is required for the person to get a job, right? But there could be some gray there, all right? There could be some gray there. I mean, you could have a situation where there's a certification that's not required in a particular state, but is practically speaking, a prerequisite for someone really being employed. And I think that can be a dangerous line, right? So the conservative approach would be, you know, if it's a totally optional type of licensure and it is not necessary for someone to get a job and you have many graduates who get jobs without this licensure, I think that's one thing. But I just think you want to be real careful if you're really dealing with something, even if it's not required as a matter of law, but functionally is necessary for folks to get employment. I would be careful in that situation. And certainly if it's required under the law, you know, you would want to address it. For the state licensure disclosure, what should foreign-based schools disclose? Interesting. So if you are overseas and you're offering a program and there's some sort of licensure, you know, and if you want to follow up with me offline, I could see a couple of different variations there. I mean, if you're talking about, you know, do most of your graduates, are they overseas as well, and are they getting jobs overseas as well? And, you know, at that point, are we talking about trying to get a grip on foreign licensure requirements, or do you have folks who are, you know, doing a study abroad semester or some portion of a program overseas at your location, then going back to the States? I think the answer is going to differ a little bit. Also, it's probably going to differ a little bit based on your Title IV population. So if you're a foreign institution and you've got 1,000 students and 3 of them get federal financial aid, I think that's one thing, right? But if 900 of them get federal financial aid, I think it's another. That's a good question. That's a good question. Let's see. Regarding disclosure, it sounds like this includes any email marketing to prospects or students about specific GE programs. Yes. If you are sending out emails, email blasts that are marketing pieces about specific programs, I think you would be hard-pressed to argue that they are not covered by the disclosure requirement. They should include, in my view, at least a link, right, and a direct link to the disclosure template. Can we include the GEDT with the enrollment agreement, which they review before signing, then have them initial acknowledgement as part of the agreement itself? Yeah, I think you could. You know, I sort of like having something that's signed separately and where you can document that it was signed somehow in advance or apart from the enrollment agreement. I mean, I know that this is getting very into the weeds here, but, you know, if they were sort of signing the enrollment agreement and solidifying the obligation and then secondarily underneath that signing receipt of the disclosure, you know, the department could argue, well, quite literally they signed the enrollment agreement before they actually gave you written receipt of the disclosure, right? I mean, I would just think, honestly, it would be easy enough in the context of the admissions process to sit them down and have them sign what, like the pre-enrollment checklist or something like that, or the face of the disclosure right before they walk through the actual enrollment agreement. I'll leave that to you. I do not think there's an issue of having them review the disclosure immediately before they sign the enrollment agreement. So, you know, as part of that sit-down process. Now, that won't work for the student warning because you've got the cooling period. But when you're talking about just the standard disclosure, yeah, that would work. I mean, there's nothing that would, you know, just put it in the packet of all the things you give them. The way I usually, when I work with schools, you know, you've got a stack of stuff you're going through, and the enrollment agreement's the very last thing. So we've got the pre-enrollment checklist, and as we hand them each document, you sign off the pre-enrollment checklist and have them initial they received it, and then finally they get to the enrollment agreement. Everything's sort of tied up with a bow. Would we be in compliance if we email the template and request students to acknowledge receipt by initialing an appropriate provision in the body of the enrollment agreement? Yeah, that's interesting. So this is interesting. You know, folks, I haven't seen any guidance from the department, again, that gets this specific. But I just think you're sort of getting really close to the line when they're actually, you know, the law says is you're supposed to acknowledge receipt of this thing before you sign an enrollment agreement, and what you're doing is you're embedding their acknowledgement in the body of the enrollment agreement itself. I'm not crazy about that. I mean, and again, you know, and this comes from a guy who has done, I mean, I was in-house, so I don't want you, this doesn't come from a lawyer who's never been on the other side of the phone. You know, my experience has been it's not that hard when you got a stack of documents to just have something separate on top of the enrollment agreement that can be signed and that they can acknowledge was signed before they actually sign the contract, right? And I think that's much cleaner, and that's the way I would recommend you do it. But I can't say that the department has issued any kind of guidance or spoken specifically to this particular question. If students withdraw and reenter, are new warnings required to be provided to the student? This is a great question, and it gets me on one of my little pet peeves here. So I know in higher education in the industry, we think of a reenter or a re-enrollment differently from a new enrollment. But from a legal perspective, you know, from a regulatory perspective, when somebody withdraws, right, they cease to be your student. And even if they come back in 3 months or 6 months or 2 years, they are still, from that standpoint, a new enrollment. They no longer have a contract with you, right? I mean, the old enrollment is done, and the contract they previously signed governed their prior educational experience. You know, there are some traditional institutions out there that have a process by which someone would be considered, quote, enrolled, even though they might not take a course for a term or a couple of terms, they're still actively enrolled, and it's just a question of whether they've actually registered, but as long as they're paying some fee, they're considered in an active enrollment status. That would be different, okay? So if someone is actually in an active enrollment status throughout the period, that's different. But that's not what I suspect is being asked here. And most of the career schools that I work with, when you're talking about a re-enroll, you're talking about somebody who withdrew, right, and left the institution and now has come back. And my view is, in that case, you should absolutely be giving them the current disclosure or student warning, particularly if it's changed, right, from what they would have received previously. I mean, I definitely would not want to argue because they're re-enrolled, they never got the student warning at all. You know, if they got the student warning and were gone for a term and then re-enrolled, I mean, at least then you could argue, well, they've seen it and it hasn't changed. But again, my advice is if someone comes back, even if they're a re-enroll, when it comes to things like these required regulatory disclosures, you should be giving them all again, right? Let's see, institutions can't confirm whether credits would transfer for failing programs to other institutions. For those institutions, maintain the option to accept or reject. Where does this leave us with the warning requirements? No, I understand, right. So the prerogative to accept credits is with another institution. But what if you have an articulation agreement, right? Or something along those lines, or whatever, you know, it's a sister institution under common ownership where you have some sort of arrangement or consortium arrangement. I mean, there could be arrangements that you have in place. The other thing is you can provide that information and qualify it. You know, you can say we have, you know, we've had graduates who have successfully transferred to this school and it's accepted our credits, you know, but keep in mind in every instance it is always their prerogative, blah, blah, blah. But, you know, I think the point that the department is making is if you have information about transferability of credits, right, that you should be providing it. I'll go back to my original point, which is I would use this as an opportunity. I don't think you're being asked to make any statement that is certainly untrue or to even speak to something like if you don't have any transfer opportunities, I'm not sure, and this is something that I'm going to punt on this a little bit because I'm not your lawyer, right? And by that I mean everyone on the line. If you are my client, I would be willing to have this conversation with you because I think there's some risk here that you have to think about. But I think you could look at the way the law is written and, you know, the obligation is if you do have certain opportunities available to talk about them, that may not mean, if you do not, that you have to include an affirmative statement saying we do not have these opportunities, right? There's a fine line there, and there is some risk, I think, if you decide to go that route, and I would be happy to assess that risk with my clients. So one point is, for you to think about with your counsel, if we don't have any transferability options, do we have to make any kind of statement, right? But if you do have something like an articulation agreement, I think it would be covered, but more to the point, I think you'd want to say that, right? Because you want to let a prospective student know if you enroll and something goes south and you can't finish or you don't have federal financial aid eligibility, we have an arrangement in place with the school across town, so rest assured you will be able to complete your program. It's a good question, though. Great, they all are. Let's see. Regarding licensure information. Regarding licensure information, what information do online schools operating in all states need to provide? Yeah, it's complicated. So if you're offering, you know, some type of certification program and you have done the research in 35 states, right, and you've got students enrolled in those 35 states, I think, and again, you should talk about this with your counsel, but I think you could certainly read the requirements to suggest that you need to be providing licensure information for all 35 of those states, right? And I'm not talking about, you know, state authorization and SARA. I mean, you know, professional licensure information. So let's say you're a for-profit institution and you offer a master's in education, right, which is designed to permit people to become licensed in their state so that they can work in the public schools, right? Teaches sort of a teacher certification program, something along those lines, and you've got people enrolled from 35 or 40 different states. I think absolutely there could be an obligation here that you need to be disclosing that information in the template. And I'll just say beyond that, you really want it on your website too. I mean, if you're offering that kind of program, you know, I have some clients that offer certain types of nursing programs and things like that, you know. I mean, you have to really be careful about what you're telling students in all these different states because you want to be sure that you're protecting yourself so that they know when they are going to be eligible to become licensed to do whatever it is they want to do in their state and when they're not going to be eligible. And you want that information to be clear. Hopefully it's already on your website and it wouldn't be that difficult to pull together and put into the disclosure template. But the bigger point here is, yes, I think it is entirely possible in certain circumstances that you would be required to provide that information for all of those states. Do you think states like California will fill in the areas the Department of Education leaves open? We're subject to BPPE rules and regulations, and I'm wondering if they will up their rules. Yeah, who knows? particularly when it comes to California. It's hard to say. They are certainly a consumer-friendly state, and I know they and Massachusetts and a number of other states out there have great interest in coming up with their own disclosure schemes, and whether those will somehow marry up with and coordinate with the federal disclosures or not is hard to say. I will tell you, in my experience, most states do their own thing. And frankly, in those instances where they've attempted to piggyback on federal disclosures, it's often problematic if laws change, right? So Illinois has built this disclosure process that rests on top of gainful employment. So if the feds stop enforcing gainful employment or change their laws, the question is, well, where does that leave the Illinois requirements? Because they're still on the books. So, you want them to coordinate. Sometimes it can be hard for them to do so, and sometimes it just creates a mess. But when it comes to California, I'll just say, I don't know. They may. Certainly, they've done it before. There are a number of people out there, Representative Waters, for example, who feel very strongly about disclosures that are being made. Do I need to participate even if all I receive is federal Pell Grants? If you have a gainful employment program, then you would need to consider whether or not certain the disclosure requirements apply. Now, you may have, and they would, because you've got people who are receiving Title IV. You would, and really whether or not it's a gainful employment program is independent of whether they're getting just Pell or Pell and Title IV. Now, some of the information is going to be favorable. I mean, if you only do Pell, then presumably some of your median loan debt information, Title IV debt information, your DE rates, things like that are going to be very positive. But yes, if you're a Title IV participating institution and you are a for-profit institution, your programs are gainful employment programs, and you're going to be covered by these disclosure requirements. Let's see. The disclosure guide displays a time frame for each of the cohorts. Should we use what is stated within the guide for the disclosure templates in January 17? You know what? I don't have that guide in front of me. I'd have to look at that. But certainly, I would take a hard look at anything the department's put out and see if it's helpful. If it creates tension with what more recent guidance seems to suggest, then like so you can reach out to me or your counsel, or even to someone over at the department. I will also say, when it comes to these little questions, meaning questions that aren't necessarily offensive or aren't going to get you in trouble, or so if you've got a technical question about the way something's supposed to work, like this, like, well, what's the exact cohort? The disclosure requirement's not even in place yet, so there's no question. You could reach out to the department and there wouldn't be some issue that they would come back with an answer that might leave you out of compliance. You don't even have an obligation yet, right? The department does have specialists now. They've sort of got a division of folks whose purpose is really to answer those types of questions. I'm not talking about the folks doing the program reviews, but sort of the folks who are there to answer day-to-day questions, try to help with some of these technical kind of things. And you might consider reaching out to them if it makes sense, and maybe you have a good relationship with them. Let's see. These time frames appear in the template guidelines on pages 18 to 21. Should we use these specific time frames? Again, I'm not looking at the template, but I would always consider any guidance from the department closely, right? So that's all the questions. We're a little over, but hope folks found it useful. As always, thank you for tuning in, and keep an eye out for future webinars and blogs, because we will have them forthcoming. Thanks, everyone. Have a great afternoon. Bye.